All right, thank you. Now the fun begins. We have now a panel on transitional justice in Israel-Palestine, return as an act of justice. We have four distinguished panelists. The first person who will be speaking is Dr. Munir Nuseibah. He's a human rights lawyer and academic based in Al-Quds University in Jerusalem. In 2006, he co-founded and headed the Al-Quds Human Rights Clinic at Al-Quds University, the first accredited Arab clinical legal education program in Palestine. And he is teaching their human rights advocacy mechanisms under occupation for law students through theory and practice. He completed his PhD degree at the University of Westminster in London, UK, just this summer, so we congratulate him. His thesis is entitled Forcible Displacement in the Palestinian-Israeli Conflict, International Law and Transitional Justice. We have also with us Professor Dan Rabinowitz, who is teaching in the Department of Sociology and Anthropology at Tel-Aviv University. He specializes in ethnicity, nationalism, Middle East studies, and the nexus between society and the environment. The professor was a visiting professor at Princeton, New York University, and the University of Toronto. He has published numerous books, including Overlooking Nazareth, The Ethnography of Exclusion in Galilee, The Stand Tall Generation, Coffins on Our Shoulders, Mixed Towns, Trapped Minorities, Here It Comes, How Do We Survive Climate Change, and Driving Forces, all very intriguing titles. He is published in leading social science journals, including American Ethnologist, Critical Inquiry, International Journal of Middle East Studies, Journal of Anthropological Research, Annual Review of Anthropology and the Environmental Justice, and more. He is a regular op-ed contributor to Haaretz and appears frequently on Israeli TV and radio. We have also Yoav Kapshuk, who is a PhD student in the political science department at Tel-Aviv University. He also teaches as an adjunct lecturer at Shapir College. He is a researcher of the Israeli-Palestinian conflict and focusing on transformation processes in ethnic and national conflicts. He is the editor of a volume called The Public Sphere, 6, One State Solution Between the Jordan River and the Mediterranean, Fiction or Reality, that was in Hebrew. And the other panelist is Marijana Toma, who is the Deputy Executive Director of the Humanitarian Law Center in Belgrade. She is in this center coordinating the program, a program on education regarding transitional justice and reconciliation strategies. She was the coordinator of the task force group that was responsible for drafting the mandate for the regional commission that established the facts on war crimes and other serious violations of human rights committed on the territory of the former Yugoslavia. And she also has a broad comparative expertise on transitional justice, having worked with the International Center for Transitional Justice in Cape Town, South Africa, and also is engaged in research on Guatemala and, of course, Serbia. So welcome to all the panelists. Dr. Munir, please.
Thank you.
One point for the panelists. We've reserved 20 minutes. I would hope that you look at that as a maximum and try to minimize comments so we can have question and answer. At minimum, we now have reserved 15 minutes for questions and answers, but hopefully we can have more time. Thank you.
Thank you.
Thanks.
Thank you, Leila. Assalamu alaikum, shalom lachem. I'm going to speak in English, so for those who need translation. I have recently, as Leila mentioned, graduated Westminster University with a thesis that actually looks at transitional justice and forced displacement. The reason why I did this thesis was because I saw a handful of articles, a starting literature that was discussing transitional justice, and mainly on the issue of the Palestine refugees, and asking and mainly looking at truth commissions. The main purpose of this literature was to argue that truth commissions would be a suitable measure to redress the refugees of 1948. Questions came up into my mind about, is transitional justice about truth commissions, or is it actually a wider concept? And that's why I did this study. The first thing I thought about was, why do we always talk about the refugees of 1948 only? And is this the right context to think about when we want to redress the refugees? Obviously, as you all might know, or many of you, especially those like maybe Jeff Halper and many others who are activists in the field, you would recognize that forced displacement is continuous. It did not only start and end in 1948. During my study, I identified 6 methods that Israel uses to systematically displace Palestinians on a daily basis. One of them was war, right? The wars of 1948 and 1967. We all know that 80% of the Arab populations of what became Israel in the 1948 war were displaced in the during the war, forcibly. And 1/3 of the population of the 1967 occupied territory was also displaced during the 1967 war. But then the thing is that when you see the peace process and most of the discussions and even the literature, you will always realize that this is the main item that is talked about in relation to the peace process. But if you look at the facts on the ground, you will notice that there is also personal status engineering, what I called engineering, which includes residency revocations in the West Bank and Gaza, which happened around 250,000 people were revoked of their right to reside in the West Bank and Gaza, excluding East Jerusalem. Residency revocations, which happens every day in Jerusalem. And we have almost, more than 14,000 people whose residencies were revoked and who are not entitled anymore to live in Jerusalem. And this whole thing about family unification and many other important ways for people that allows them to live in their homes are now problematic in the Israeli law. I'm not going to explain this a lot, but this is just the background. There's the issue of urban planning, which, as you can see in this picture in Al-Araqib, whole villages are being demolished because they are unrecognized. Urban planning in the state of Israel is very discriminatory. The state of Israel is planning cities and villages and towns and for the Jewish population, and at the same time it is not only ignoring the Palestinian population, but making sure that they stay in as small spaces as possible. Dispossession of property, and Leila has spoken a lot about this element. There are people who are deported on security justifications, and there are also unbearable circumstances that are built, for example, by the wall around a certain village that forces the majority of the population of the village to leave. So these are the 6 methods that I managed to identify, and maybe some of you will come now and say, no, there is actually a 7th or an 8th method, but these are the ones that I managed to identify during my study that are happening every day. Hence, I would argue that the policy of forced displacement is a very stable and strong policy that Israel uses, unfortunately. Especially when it comes to the right of return of the Palestinian refugees, and in the discussion about the refugees, we have always seen, at least for the past maybe 20 years, 2 approaches that are competing when they speak about the peace process and the refugee problem. One of them is called the rights-based approach. That's a strong stream of literature that has been led by a number of scholars and a number of activists. And the main idea is the Palestinian refugees are entitled to return to their homes and are entitled to restitution of property and all of the other legal remedies because their displacement has been illegal. Therefore, the state of Israel has to accept their return, and that's it, period, right? This has been known as the rights-based approach. Of course, it is more detailed and more complex than that, but that's maybe if I try to summarize it, that's what it is. The other one is the realistic approach, and this is a Palestinian approach right now, and also partly Israeli, of people who maybe don't recognize the injustice that happened. They do say that what happened in 1948 and the displacement of 80% of the population and their dispossession has been illegal and illegitimate. However, the current peace process that is being led by the United States and Israel, and the current competition and the imbalance of power between Israel and the Palestinians means that we have to accept the fact that the refugees are not going to return. These are the two main competing theories right now. So my thesis comes in the midst of this discussion, especially that there is this merging discussion about transitional justice. As I mentioned before, most of the transitional justice literature is all about truth commissions. There is one specific paper that might be interesting to quote here, and that was published by Yoav and Nadim Rouhana, where they argue that transitional justice does not seek to achieve a balance between the violated rights and compensatory measures. The main point of the paper was that while Israel needs to recognize the Nakba, right? To recognize the Nakba and to accept that the Nakba is a mistake and to apologize for it. And not only the Nakba, that Israel needs to recognize the right of return, right? To recognize the right of return, but the actual implementation of the right of return is a different story. So there was Peled and Rouhana created a difference, and a theoretical difference between recognizing the right of return on the one hand and the implementation of the right of return. So my question was also, is this actually transitional justice? This has been the question. Does this really represent what transitional justice is about? Does this come from any theoretical or practical method that has been used somewhere in the world, or is it just a repeat of the realistic approach? And that was the main issue of my study. So what is transitional justice? Transitional justice is a number of measures that are mainly truth-seeking, accountability for crimes, reparations that were explained to us by Leila before, and legal and institutional reform. These are the four categories of measures that are usually used in the context of transitional justice. Ruti Titel explained that transitional justice is also a theoretical framework. It is a way to think during the times of transition. We are going from conflict to post-conflict. What we are aiming at is to redress the victims, right? So the main idea of transitional justice is actually giving the victims the feeling and the actual redress of their rights. When I had to study this, the concept of transitional justice, I had to think of certain methodological questions. First, the the transitional justice as a conception of justice is based on international law, right? So when we think of transitional justice and the framework of transitional justice, it's not based on morals. It's not only based on friendship. It's not only based on love. These are of course important elements that we would like to achieve. However, international law is the basis of transitional justice, and this can be seen in several examples that maybe I will mention some of them. Secondly, transitional justice stresses the element of comprehensiveness. Comprehensiveness is a very important element in transitional justice. And by comprehensiveness, you normally hear that a state is expected to comprehensively, holistically, redress the victims of human rights violations, to give them all the remedies that they are entitled to. But another element that I also found is that there needs to be a holistic understanding of the problem in the first place. And that's why I did not only study the refugees issue of 1948, but the whole issue of forced displacement. In most of truth commissions that have been established in the world, and there have been until now more than 40 truth commissions, you will see that the mandate of truth commissions is always about not only what happened, but the context, why it happened, how did it happen, who did it, who was the victim. The big context is a very important element of understanding the problem, understanding the violation. Therefore, it's very important that you have a comprehensive understanding of the problem in order to be able to resolve it. But at the end of the day, what transitional justice is, who likes maqlube? All of us do, of course. This is a description that I used one time, and I like it. This maqluba is actually a picture from my home. It's my mom made it, but the others are from the internet. So the idea of transitional justice is that it is like cooking. You have a problem, you want to solve it, and you want to redress the victims. It is like cooking a meal. You need to add every element like a recipe. You cannot just come and give only truth commissions and think that this is going to solve it. I cannot only put rice in order to make maqlube, and I cannot only put vegetables in order to make maqlube. To make any dish, you have to put all of the ingredients, the necessary ingredients, and you have to put them in the right time and the right place. And this is what this is the relationship between transitional justice and international law. Transitional justice is actually the international law measures put in practice. And then let's look at, just very quickly lay out the different methods that have been used. The first one is truth commissions. The truth commissions have been used to redress victims of forced displacement in different places around the world. I would mention the examples of Liberia, East Timor, Sierra Leone, and others. But I think it is important to look at the forms of denial that Israel is using. If we want to establish truth commissions, what would these truth commissions need to address? The first one is that, as we know, Israel explicitly denies that it has violated international law in the first place, and that it has actually displaced the Palestinians intentionally. This is denial, but there are many other forms of denial. One of them is the secret laws. For example, when Israel started to displace the Palestinians in Jerusalem by revoking their residency, Israel never actually announced that this is a new law. It just, people were shocked by just having their residencies revoked. There are many other examples of this type of denial. There is another example, which is blaming the victim in the court. Because forced displacement is actually part of the legal system of Israel itself, then if somebody in the court tries to argue against his own displacement, the court will blame him for his displacement because, well, you infiltrated well, someone, this is a case called Shaheen case. Somebody was just returning to his home, and the court found him an infiltrator, which is one of the laws that Israel used to displace people. And then the court told him, you infiltrated Israel and came to your home in Gaza, actually, in the Shaheen case. And therefore you are not entitled to return. So he was blamed for being deported while he actually just was returning to his home, right? And even the peace process has used, the current peace process that we know, the Oslo framework, has used many types, has many types of denial. For example, with the reissuance of lost ID cards. There was reference about the residency revocation policy in Israel, and it was called that people who lost their ID cards, as opposed to people whose residences were revoked and who was expelled, they were called people whose ID cards were lost, and that the return of them would be simply reissuing their ID cards. Even the language there's so much denial, not only in the Israeli language, but also in the peace process that the Palestinians are part of, right? So the whole peace process right now is full of this denial. And what's most important is that each one of us, people who work in different things that have to do either with the refugees or with home demolitions or with this or with that, we all know pieces of the facts, and we know the facts, and we tell the people about the facts. However, knowledge is not enough for transitional justice and for truth. There needs to be also acknowledgement. We want to see one day Israel saying, well, we have been displacing Palestinians because we want to make some demographic changes, right? And this has been wrong, right? This is what truth is, right? But there are many other. Truth is only one of the elements of transitional justice. The other one is prosecutions. As many may know, there have been normally in the world two approaches about prosecutions. There is restorative justice and retributive justice. Restorative is more about forgiveness and compensation, redressing the victims in many other ways that would not include the punishment of the perpetrator of the human rights violations. Retributive justice is more about punishment. Certainly, what I would say shortly, because I'm almost short of time, is that prosecutions is one of the elements, and forced displacement is both a war crime, if it is done in an occupied territory, and then a crime against humanity, if it is part of a wide spread policy, or if it is systematic, right? So by each one of the displacements that are taking place now and that have taken place in between 1948 and now, each one of them is a crime, right? And this means that prosecutions and individuals being prosecuted in a criminal court for this crime is a proper answer. And there has been many domestic and international courts and tribunals that took place to prosecute perpetrators of forced displacement. Among the domestic prosecutions were in Colombia and Estonia, and among the international ones would be the Nuremberg one and the one in Yugoslavia. Finally, I would say reparations. I will not talk about restitution and return, although I would just stress that return is certainly part of a transitional justice method. You can never imagine redressing a victim of a human rights violation without allowing the person to return and to implement his own, to get his own right. But I would say that the reparations will certainly need a legal reform and institutional reform. And this is maybe the most important point that I left to the end. The state of Israel has forced displacement as part of the state, as part of the system. It happens according to the law. I cannot imagine a transitional justice process that will take place in Israel and Palestine while forced displacement is still continuous according to the law. If the law is not going to change in a way that establishes equality between Jews and non-Jews, we cannot imagine a transitional justice process. So only apology or even other remedies that will happen while the law is still discriminatory would be meaningless. This has been proven in different places around the world. I don't have time to go through the experiences, but I would maybe very quickly say that in South Africa, when South Africa was starting to establish a transitional period, they had in their transitional constitution a principle called equality. Under the principle of equality, South Africa put restitution of property for those who were displaced and dispossessed by the South African discriminatory law. I would say that this is what we need here. We need the principle of equality to put us on the road of transitional justice in the first place. Thank you.
The next speaker is Professor Dan Rabinowitz, please.
Thank you, Leila. Shalom lekulam. Salam alaikum.
Hello to everybody. Salam alaikum. And
We need technology to follow. אני רוצה להתחיל.
I would like to begin and first congratulate Zochrot for this important day and also for the symbolic choice to hold it here on the lands of Sheikh Moanis, the village that used to be here and flourished here until 1948. I think it's clear to us all that without progress in the question of the refugees, we couldn't possibly come to any kind of resolution between the Israelis and the Palestinians, and for reasons that I can't enumerate here today, on both sides of the aisle, Israelis and Palestinians, there is no true public and critical and creative discussion in the issue of refugees. Now, the refugees and the politicization that has occurred since 1948 onwards, of course, are part of our public agenda, and we talk about it. That's true. But dealing with the refugees and their fate is done in a coerced fashion. It's done in a superficial language. The leaders of both sides that deal with this deal with it as an issue that's a non-issue, and their contribution is oftentimes manifested in sort of ritualistic slogans and purist slogans that means nothing in the name of absolute justice, as it's considered by the Palestinians, demanding full return, comprehensive return immediately of all the Palestinians to the land, and from the Israeli side, of course, according to which there is no right of return, only for Jews. And so this is why such events as held today is so important, and why I'm so glad to speak in Hebrew here today. Now, various versions of the paper that I'm going to talk about here today have already appeared in various publications in Hebrew and in certain publications in English as well, and I've also said these things in certain versions. But apart from a few articles in the Haaretz newspaper perhaps a decade ago, I really haven't had many opportunities to say what I'm about to say as part of the public agenda of Israel. And in the first part of my article, I'm going to talk about transitional justice here in Israel within the Israeli context. I'm going to try and be very, very brief. In the second part of my lecture, I'm going to try and produce a few principles that I think are practical implemented practices that could help us along the way, while talking a little bit about the symbolic and demonstrative and declarative elements that are usually part of transitional justice. I asked the conference organizers to be part of the panel that has to do with transitional justice, because I think any resolution of the refugees must be based, at least partially, on the model of transitional justice. I would like to remind you that unlike absolute justice, in which the declared ambition is that all of the people who did the wrongs will be brought to justice, and the victims will receive full restitutions. Unlike that, transitional justice is basically a trade-off. It's a compromise. It's not a trade-off between both parties, really, so much as it's a trade-off between the victims and reality, between the current reality and the time that's elapsed. Now, within this compromise, the victims let go or waive their full rights to restitution, and they also forego any kind of real legal procedures. And as we've heard from the previous speaker who just spoke with his retribution justice, it's not where everybody who did something wrong is brought to justice. In Nuremberg, for example, not every single Nazi was sent to trial. It was a small group of people. It was a very important and also symbolic act, but we basically forego indicting thousands of Nazi officers. So in transitional justice, the victims basically agree to a compromise, to a trade-off. For example, Truth and Reconciliation committees will allow you to get a full public acknowledgement of your victimization. Maybe you help you in dealing with the emotional baggage that continues to weigh down your life as a victim. The people responsible for the crimes, on the other hand, are for the first time in their lives indicted and forced to look in the eyes of victims and their family members to hear their side of the story, to hear their perspective as a legal truth, as an accepted truth, and maybe also have a time of redemption, maybe an opportunity to ask for forgiveness. So a true correction of the Palestinian situation therefore must combine elements of ultimate justice and transitional justice. It cannot only be based on the hopes of ultimate justice for several reasons. First of all, the 65 years that have elapsed have changed the situation here in Israel for both sides of the aisle, and they don't allow a full return of the Palestinians to the life that they had before 1948. There are other people who live here. There are cities that have been built in the lands that they used to live here. There's almost no correlation between the people who were victims 65 years ago and the people who were, so to speak, criminals. Jewish settlements have been moved, have been established. There's scorched earth policies. All of these things are impossible. And anyway, none of these things are feasible, so we don't consider that. A full return of the pre-Nakba days is also completely impossible because 2/3 of the original refugees are already dead by now, or roughly so. And because polls that have been conducted by ICRI in 1991 and Chikaki in 2003 show us that the vast majority of the descendants of the refugees or their family members are not really interested in coming back to this land, to the previous land that they occupied, if this means living under Israeli regimes or even with Israelis. So these polls, these two polls, and also many other polls that have been conducted later, do indicate that the descendants of the refugees are far less determined on right and return. But also for the descendants, it's clear that right of return today is not going back to the Palestine of 1948. Thirdly, a complete return of refugees that will be a part of the ultimate justice kind of model is completely unfeasible in terms of the Israelis. Israelis will not accept a full return of millions of Palestinians. They would consider it's the end of the Israeli era. So for those of you who continue to insist on ultimate justice for the Palestinians, is really deluding themselves if they're saying that they're really working towards Palestinian interests. This kind of insistence, this stubbornness, is for people who make their careers from being in protests and being activists and continuing to insist on ultimate right of return for the Palestinians. This has nothing to do with anything feasible in any true resolution that will actually give retribution to the 2.5 million refugees or 1.5 million refugees that are still living in camps in Lebanon and in Gaza and so forth. And so between that kind of mentality and reality, there is a chasm, a huge chasm that will never be bridged. You can say that you want ultimate justice, but it's really left for those who want to entrench themselves in archaic tenets that have nothing to do with reality. For those who want to be more practical minded, will have to let go of ultimate justice altogether, and whatever they feel about it, walk towards this model of transitional justice. And in the seminar today, and this panel is not the first to try to encourage this idea of transitional justice in terms of a solution for the refugees. In Camp David already there was an Israeli formula that talked about acknowledging the right of return of the Palestinians, but also freezing the implementation of this right, and this allegation that acknowledging this was a key symbolic act by the Jews that could prove part of a resolution would be something that we see in several articles. For example, Amar Ben Benisti's and Chaim Gantz's article that was published in English in 2003. for example, and also an article by Peled and Ruchana, which was already mentioned today in one of the lectures. And there as well, the idea of an internal replacement of the refugees, meaning people who live in the area, don't live abroad. This would be not only a symbolic act, but working towards some kind of restitution. This would be the first thing. And also Ilan Lustig and Anne Lash's book about right of return, they talk about this kind of mentality as well, a domestic replacement. And also Susan Selimovic, who talking about reconciling the two situations between Tibino, who used to be previous rebels of the state in Morocco. She gave that example, and also many economists and also other people who talk about this monetary restitution to the refugees, at least for their lost possessions, and investment of the national infrastructure that will also help the situation. All of these suggestions are built on understanding the very symbolic importance of such restitution and its potential contribution to forwarding and encouraging transitional justice here in Israel, just as there was between Israel and Germany in the 1950s. This act also had enormous monetary implications, but enormous symbolic implications as well. There's no doubt that the resolution of the tragedy of the Palestinian refugees will have to be a return of possessions, if such possessions already exist, realistic remuneration of possessions and assets, compensation, and I'm going to really try to, I'm using terminology here very, very accurately. I hope this is understood, the difference between restitution, remuneration, and compensation, and I'm really dividing between the three things. And also it must include a sort of creative solution to some sort of rehabilitative progress, something done for the refugees. And I think broadly we can agree on this, and I think there is an understanding that there's a political desire to deal with the issue of refugees, and with enough political desire we will find the clout to implement these things. For example, the return of available possessions, remuneration on lost possession and assets, creating some potential to receive or absorb several of the immigrants, perhaps not the vast majority of them, but at least some. I think these are all solutions that are certainly feasible. But I claim that these, even returning the domestic refugees here in Israel as some sort of symbolic act as suggested by Peled and Ruchama, that's not enough. That's what I'm saying. I think the issue of the Palestinian refugees will not go away unless we find a formula of return within the state of Israel that will answer two criteria that will be more than a fantasy. First of all, that the mainstream of Israel will be able to agree to this, despite the existential threat, the existential fear that exists among Israelis that too many Palestinians coming back to Israel will be a terrible threat to Israeli existence. And secondly, that the disadvantages by the Palestinian side will be by the Palestinians who only dream of ultimate justice, ultimate right of return, where all of the Palestinians come back, and that we balance it out by all sort of symbolic acts that are within the spirit of transitional justice. So my solution talks about a significant right of return, meaning a lot of Palestinians coming back within the Green Line borders. And I emphasize this because a return to their homeland is a very important point. I think it's very important when you bring back Palestinians to a Palestinian country, to where they come back to their actual previous home, to the houses that they were displaced from. So I think this is very important, because going back to a Palestinian state, if such a solution should ever come to pass, is of course something that offers the refugees to go back to their national home countries, and I don't think this is a small thing, certainly not, but it lacks the very important symbolic act of coming home. And I think that that is a very central point. Now I'm going back to the second point. It's going to be briefer, and I want to really give you details of the formula that I suggest, that I believe answers these two criteria and combines between operative elements and between symbolic elements that can move us forward in the process of transitional justice and reconciliation. The first principle is that Israel declare a quota, a number of refugees refugees that have right of return and that have Israeli citizenship right away. Now the question is, of course, everybody asks is how many? What's the number? How many will you allow back? Now there are all sorts of discussions between Israelis and Palestinians, oftentimes sort of friendly even chats where Palestinians say we have to say a full right of return and full citizenship to all of the refugees, if it's 6.3 million refugees, as some people claim, especially if it's 6.3 million, and the Israelis say we can't live with those kind of numbers, and the Palestinians say, but not everybody really wants to come back. And I agree with this declaration, and the polls that I've already mentioned validate this declaration. So it's true that not all the Palestinians want to come back, but we're opening up a very problematic area of uncertainty for both sides here. And so I continue from here. The number, the quota that I suggest is not less than 200,000. That's what I suggest. 200,000 is not an incidental number. This is basically the proportion of the number of original refugees that are still alive. By the way, it's also twice or three times or even four times the largest number that Israelis have ever been willing to officially consider within returns of the Green Line borders. So it was in Camp David in 2000, they talked about 50,000, and one time when they said 100,000. So I say no less than 200,000. And I think the symbolic importance of this is that theoretically it can include all of the original refugees. I think that's a very important point. The second principle is that the people who determine who will be on the list of the 200,000 will be decided by the Palestinians. The Palestinians will decide who's in that quota. And if somebody asks me, then I would say that as somebody who wants to believe in transitional justice, I would recommend that the most reasonable thing is to suggest the first rights of return to the original refugees that are still alive, meaning the original people, the actual people who were taken out of their homes in 1948 and now can come back. Now the third principle is decoupling between citizenship and residency. The Palestinians that will be included in the 200,000 quota will receive full citizenship, will not be forced to leave their lands at the moment and come back to Israel in order to realize their rights. They won't have to come back. The rights will be offered to them, including national insurance and medical insurance and all that comes with that, and they can remain in their home countries at the moment, meaning complete decoupling between where they live and how many rights they have. There have been in the last few decades all sorts of models that have been enacted in order to do this decoupling, and I'm certainly sure that in Israel with very simple legislation it can happen as well. The fourth principle is for those who will be offered citizenship and completely forgo it, and as we see from the polls, there's lots of people who don't want to come back to Israel and don't want those rights. Their number in the quota or their place in the quota will be given to another Palestinian, again according to terms and conditions that can be set forth by the Palestinians, meaning an individual's right to forego or to waive their right to return or to citizenship will not to mean that we reduce the quota. The quota remains 200,000, and if you give up your place in the quota, it will be given to another Palestinian. The fifth principle is that those who will be included in the quota with full rights will also have a significant amount of time, several years, to decide whether they want to realize their actual right of return or not. Meaning at the end of the several year period, if they haven't realized their right, this right moves on to another Palestinian, again according to the terms and conditions that are decided on by the Palestinians. Now the time that people are given to decide is, according to research studies mostly by Slimovic that she examined Morocco, is a very key point. You can't just give people an ultimatum and say, leave your home now or accept these rights that we offer you now and you have until tomorrow to decide. You cannot do it that way. This is a very fateful decision for a person and their family, and you have to give them the time to come to grips with it. Meaning all of those people who are included in the initial list of 200,000 in the initial quota will also get the right to forego, and that right to to forgo these suggestions and to give it to somebody else. And if we believe the polls, many will decline this right. But I believe that their declining is not an indication of the failure of the formula, but quite the opposite. Actually, it's success. And here I come to Yuda Krista and the theoretical part of this, and I promise to be very, very concise. And this is something that I also mentioned before. In his article on the Abject theory, he writes about the physical, the corporal rejection, the desperation in which the weak defend themselves against what the strong is trying to coerce them into doing. The most famous example is the moment in which a child refuses to eat food that they find unappetizing, despite the fact that the parent is trying to push that food. And it could be tics, it could be crying, it could be whatever, all sorts of radical physical reaction. Now, Christoph really identifies those moments as a moment in which the child forgoes this ability to survive and prefers to do it because he's being coerced into something. Now, this instinct is something that really bases their ability to enforce any kind of autonomous existence. And this ability to say no, to decline, is a key point in a people's psyche. And this is the theoretical basis, basically. And on this I found
2 minutes is fine.
2 minutes, okay.
זה הבסיס התיאורטי.
This is the theoretical foundation that I found my suggestions on, and this is why I think it's so important. The politicization of the right of return since 1978 has made it so that every Palestinian must see themselves as if they themselves were ejected out of Israel, and they themselves must morally have to return to Israel, must realize their right of return. Now, this dynamic that has been created around this is something that is unhealthy, and I believe that my solution can neutralize this problematic nature and allow people to have a personal decision, something with a lot more liberty. Now, the dilemma that every Palestinian refugee will be dealing with is an acute dilemma. It's not a trivial thing. First of all, they'll be given, the rights to deal with they'll be given the right of return without having to go back physically. And this is a truly symbolic act. People that in 1948 were forced out of their homes and stripped of their rights, and now their rights are returned to them. Now, it's true that this is 65 years too late, but at least they're still alive. Secondly, it also has economic ramifications. And so even if you decline the right of return, despite the fact that you're personally maybe losing out on a family level, on a money level, it still has enormous emotional and symbolic significance. And this ability to decline, even if it's done on a personal level, means that you can really if it's done on a public level, have enormous public ramifications. And the older the refugee is, the more the powerful and symbolic their decline will be for their community, for their families. The polls of Ipkri.
Can I suggest that we refer to this remaining part in the question and answer?
Okay.
Just wrap it up, please.
אני אסיים רק בשאלה.
Let me just conclude with a question, and then I'll go back to this question. Is the formula that I'm suggesting more suitable to the Israeli-Palestinian country of a two-state solution, or is it more suitable to a one-state solution? This is the question that I raise, and I'm willing to come back to it. Thank you so much for your attention.
Now we have Yoav Kapshuk. Thank you.
Okay, I'll be speaking in Hebrew. At the preamble to the Geneva Accord to end the Israeli-Palestinian conflict, it says that this accord ends the historic conflict between Israelis and Palestinians and paves the way to reconciliation between the Arab world and Israel. End of quote. Indeed, is it a historic reconciliation between Israelis and Palestinians? Does the Geneva Agreement include the elements of historic reconciliation? This research tries to address these questions through focusing on the articles that has to do with the refugees of 48-49 and the historic responsibility for the Nakba. Through analyzing this agreement, the research will try to contribute to the literature on conflict resolution, which includes various models of conflict resolution. In order to understand the meaning of reconciliation, according to the research literature, it can be distinguished from conflict settlement, in which both sides try to reach an official agreement in a very superficial way. It is based on the forces in the ground, and therefore it does not necessarily fairly reflect the opinions of both sides, and therefore necessarily does not reflect the long-term interest of the weaker party. Reconciliation, on the other hand, is supposed to bring the parties to an ethnic or national conflict to deal with the core issues of the conflict, with an emphasis on issues of justice, which includes correcting and rectifying prior actions of injustice, putting an end to past injustices and oppression. Another key issue that needs to be dealt with is the exposure of the truth regarding past injustices and advertising these. And on top of that, you need to make both parties agree to historic responsibility over the conflict, and the offending party to confess on its part, and a mechanism that would include all these suits reconciliation. The mechanism that suits such reconciliation in such a conflict like the Israeli-Palestinian one is transitional justice. The concept of transitional justice usually addresses a conflict within a country, and I think the Israeli-Palestinian conflict has these traits because the history and the identity of the Israeli nation and the Palestinian nation are mixed in a connection that cannot be severed in the shared territory of a mandatory Palestine, the land of Israel. And in order to reach reconciliation, transitional justice can include two actions of restitution and recognition. I also use Yoav Peled and Nadim Ohana's paper, which claim that it is possible to take both restitution and recognition, and on the one hand, recognition will require the exposure of the historic truth regarding past injustice and respecting the identity and the narrative of the victims, and restitution is returning to the owners what has been taken away from them, for example, returning the status of citizenship, the return of property, and financial assets. This has to do with responsibility over past injustices, when participation in restituting for past crimes also means assumption of responsibility by the perpetrators, and this process is treated as process that takes place in post-conflict areas, that is, areas where if an official peace treaty has been signed, and reconciliation in this sense is a deep and ongoing process which it goes on beyond the official treaty. And in post-conflict areas, reconciliation description are part of the literature, the developing literature regarding transitional justice. On the other hand, there are hardly any studies regarding reconciliation and transitional justice as important elements, essential elements in the peace treaties themselves. I believe that there are certain conflicts in which elements of reconciliation and transitional justice need to be addressed at the early stages of the negotiations in an attempt to resolve the conflict, and in the official agreement itself, and not just after it. And this study will try to analyze a peace treaty through the components of reconciliation. The agreement I shall analyze is the Geneva Accord, which was signed in 2003 by key figures, both Israeli and Palestinians, and it offers a model for a final state solution to put an end to the Israeli-Palestinian conflict, which is based on a two-state vision of those who originated the Oslo process. Some of the people who signed this accord also managed and practiced the negotiations between Israelis and Palestinians over the years. The importance of the Geneva Initiative is that it is based on official talks that were done in Israel and the PA, including the Clinton outline and the Toma talks, in comparison to voluntary and official models, which have principles that are similar to a final state agreement to an end to the conflict. just like Olmert's proposal to Abu Mazen in 2008. This is the most detailed and comprehensive document. Therefore, it is a good model for analysis of an attempt to resolve the Israeli-Palestinian conflict in the past 20 years. An analysis of this initiative will focus on Article 7 that deals with the issue of Palestinian refugees. Out of all of the issues at hand, the 48 war and its implications are at the basis of the both Israeli and Palestinian identity. Both address the right of return of Palestinians as a very significant issue over both the present and the future. So for a peace treaty that will end the conflict like the Geneva model, for it to be considered as holding components of reconciliation and transitional justice, it must put at its center Israel's recognition of the historic injustice that occurred in the 48-49 war. And under this framework, Israel must acknowledge the right of return of Palestinians to its sovereign territory, while agreeing that any discussion on this will be done through taking into consideration the needs of the Jewish-Israeli party. Those who formulated the Geneva Initiative recognized the importance of the issue of the Palestinian refugees in order to put an end to the conflict and devoted quite a significant part to it. Article 7 includes 14 subsections, and the beginning of this section is devoted to the emphasis on the importance of the refugee problem. Both Israelis and Palestinians recognize the fact that an agreed resolution of the refugee problem is necessary for achieving a just, comprehensive, and lasting peace between them. So the aspiration to reach a just peace in the context of the refugee issue might allude to the fact that the Geneva Accord will express the principle of justice, which is one of the main principles in reconciliation theories, but putting the words just peace in writing isn't adequately addressing the issue of justice for refugees. In order to reach a just peace, we must address the principle of justice both practically and essentially during the agreement itself, whilst agreeing on it and relying on it, so that it will serve as a point of departure for reconciliation. It is the burden of proof on the writers, and as I progress in analyzing this initiative, I shall show you that they only rise to this challenge partially. In the second article in the Geneva Accord, various UN resolutions such as 194 and 242 are mentioned, as well as the Arab Peace Initiative regarding the issue of refugees. And these resolutions,
the basis for resolving the refugee issue, and agree that these rights are fulfilled according to Article 7 of this agreement.
On the one hand, mentioning the titles of UN resolutions in the Arab Peace Initiative, and definitely, or especially Resolution 194 that determines that Palestinian refugees are entitled to return to their homes. That's a significant progress in comparison to the intermediate agreements that were written throughout the Oslo process, in which this decision was never mentioned. But on the other hand, the formulation of this article is cumbersome, perhaps for a purpose, because of Israel's unwillingness to discuss the issue of the return of refugees. Because if that isn't the case, then how can we explain that there is no mentioning of the content of these resolutions? And especially, how come there is no mentioning of the most significant sentence which is mentioned in Resolution 194, according to which
and live at peace with their neighbors should be permitted to do so at the earliest practicable date?
It seems that the formulation of this cumbersome sentence and the fact that Resolution 194 is not specified is the desire of the signatories, especially the Israeli ones, to undermine the relevance of these resolutions by the consent of both parties that refugee rights will only be according to Section 7 of the Geneva Accord. If the parties would have avoided mentioning the names of these resolutions, especially the title or the name, the number of Resolution 194, then there would have been a basis for the argument and the criticism that the Geneva Initiative ignores it. But And the mere mentioning of the names of these resolutions, and at the same time the agreement that the implementation will be according to Section 7 of the Geneva Accord, when this was written in Section 7 itself, also makes it difficult to criticize them on the fact that they ignore past resolutions regarding refugees. The third section to the Geneva Accord, which includes Article 7.3, deals with compensation for refugees. Refugees shall be entitled
and for loss of property. This shall not prejudice or be prejudiced by the refugee's permanent place of residence. הקושי עם סעיף זה
The difficulty with this article is the fact that they ignore who is supposed to compensate the refugees. The literature addressing compensation attributes tremendous importance to the compensating entity because the compensation process is directly linked to the assumption of historic responsibility for past injustices. But throughout Article 7.3 and throughout the entire accord, there is no mentioning of the reasons that led to the formation of the refugee issue. Israel's responsibility wasn't mentioned, neither was the claim that it has no responsibility. Avoiding this means that they were trying to avoid clarifying historic truth. And even in the sections where the various elements are discussed, such as Section 7.9, Article 7.9 and 7.10, Israel is not mentioned as the entity responsible for the injustice, which is why the refugees require compensation. The ironic part is that Israel's responsibility is alluded at the exact same places where Israel tries to shed its responsibility for the Nakba. In Article 7.93, it says that
arising from the Palestinian refugee problem may be raised against Israel. משפט זה
this sentence and Section 7.7 is similar to it, with the title End of Claims, is one of the only sentences throughout this accord that teaches us, perhaps only in a hinting way, that perhaps Israel does have responsibility over past injustices caused to Palestinians. In other words, Israel's desire for this accord to include a commitment that there will be no additional claims because of the refugee issue might attest to the direct link it has to this issue, and also in an indirect way its responsibility for it. Now I wish to discuss the main article that deals with the refugees' right of return, which is Article 7.4, which appears partially on this slide because it is quite long, and it determines that Palestinian refugees will be entitled to choose their final place of residence according to the following options.
Areas in Israel being transferred to Palestine in the land swap. Third countries, the State of Israel, present host countries. A, permanent place of residence. 1 and 2 shall be the right of all Palestinian refugees and shall be in accordance with the laws of the State of Palestine. C, Option 4 shall be at the sovereign discretion of Israel that will consider the average of the total numbers submitted by the different third countries. למעשה,
So in practice, this article rejects the Palestinian refugees' right of return to the place where they lived until 1948-1949, unless they lived in territories that will be transferred from Israeli sovereignty to the sovereignty of the Palestinian state as part of the peace treaty. Despite the beginning of this article, which determines that the Palestinians will make a conscious choice of their final place of residence, only options of PPR, only PPR options A and B, which is their choice to return to territory under sovereignty of the Palestinian state, can be fully realized according to the desire and choice of the refugee.
I have 5
minutes, okay. I
נותרו
just want to say that you're going through the articles, but also I'm sure you have some analysis.
Okay, thank you.
Thank you.
האופציות הנוספות, התיישבות הפליטים במדינות שלישיות
The other options, the fact that the refugees resided in the host countries and third parties, will be under the discretion of these countries, and this enables Israel to take into it a small number of refugees, especially when it declares that it will consider taking the average number of refugees that were taken into third countries. And this declaration has a big significance because it takes off any responsibility from Israel regarding the refugee issue, because it receives an identical status to that of other countries, the third countries as they are called in these accords, that will agree to take in some of the refugees. So far, it seems that the peace treaty, according to the Geneva Accord, does not include elements of reconciliation, but there is one very important article, 7.14, that its subsections might serve as an initial measure to include reconciliation in peace treaties. And the article that its title is Reconciliation Programs determines, and I'll read speedily these three paragraphs.
Promote the development of cooperation between the relevant institutions and civil societies in creating forums for exchanging historical narrative and enhancing mutual understanding regarding the past. 2. The parties shall encourage and facilitate exchange in order to disseminate in a richer appreciation of these respective narratives in the fields of formal and informal education by providing conditions for direct context between school education institution and civil society. 3. The parties may consider cross-community cultural programs in order to promote the goals of conciliation in relation to the respective histories. סעיף 7.14 מכיל עקרונות של פיוס, כפי שרומזת הכותרת.
And so section 714, as the title alludes to it, it does allude to reconciliation in the future instead of dealing with it directly within the agreement itself. So the agreement addresses reconciliation just as they address reconciliation and transitional justice in countries where the agreement has been signed. In the post-conflict situation, enables them to discuss all the issues of justice. And the discussion, or postponing the discussion on the principles of a reconciliation, is contradictory to the request Israelis have to Palestinians to declare the end of all requests. And the first three subsections in Article 714 include words such as mutual understanding and historic narrative. Indeed, these words do reflect a discourse of reconciliation within the peace treaty, but they are almost empty of content if the agreement itself doesn't really deal with and describe the contrasting narratives and deals with them publicly. And there is another subsection, the last one, in section 7 in Article 7.14, that indeed addresses the injustices of the past, and that includes various reconciliation. It says,
developing appropriate ways of commemorating those villages and communities that existed prior to 1949.
But even this sentence is a bit vague because it doesn't exactly define whom are these communities that stopped existing after 49. It says villages and communities that existed prior to 49. These words were carefully selected in order to avoid mentioning the events of the 48 war and its implications. The fact that these are Palestinian villages and communities, the fact that this is not mentioned, it seems to be done on purpose. These words are not negative words like words as destruction or Nakba, because use of these words would have indicated Israel's responsibility to the fact that. So in conclusion, analyzing the map shows us that the Geneva Accord ignores issues of historic responsibility, justice and truth, and this includes an in-depth addressing of the events of 48, assuming responsibility over the Nakba and finding a just solution for the Palestinian refugees' right of return. Therefore, the Geneva Accord does not include components of reconciliation except for some specific ones that appear on 7.14 that could serve as an initial measure towards reconciliation. And the conclusion that comes up from analyzing this initiative, in order to reach a true solution to the Israeli-Palestinian conflict, we need to take into account elements of reconciliation already in the first stages of the Israeli negotiations, and especially to give them a significant place in the peace treaty. This peace accord could be based on the vision of the two-state solution, but there is no prevention if the elements of reconciliation will also fit other visions for peace, such as other formulas of one state from the Mediterranean to the Jordan River. Thank you very much.
Okay. Marijana, Toma.
Thank you very much. First, allow me to thank the organizers, Zochrot organization, that invited me to come here and speak and share some of the experience from the former Yugoslavia with the actually more on Serbia and its experience with application of transitional justice principles. I was actually very worried when I received the invitation to come to this conference that everything that I have to say is it's not going to be interesting for you, since these are, I would say, two different cases of transitional justice. In former Yugoslavia, we have some of the mechanisms of transitional justice, as my previous colleagues were very kind to present what they are. And I see this case as a more of a pre-transitional justice case, which basically, and I think it is actually, you are in advantage, because we were not thinking about transitional justice before international community came to us and told us what to do. So, and then we had to be creative how to actually repair the damage that was inflicted on us by the international community and its solutions. So I would just like to give you a brief introduction, if it is possible to give a brief introduction about the wars in former Yugoslavia, and then to turn to what Serbia, as one of as the biggest country of the former Yugoslavia. There are now 7 of them established on the territory of one country. What has Serbia done until now in the area of transitional justice, with specific focus on accountability for war crimes and human rights violations that Serbian forces committed during the wars in former Yugoslavia, and also some truth-telling initiatives, and also a little bit of reparation that we actually have in our country. So, the solution of the Socialist Federal Republic of Yugoslavia, that started with the declaration of independence of one of its republics, Slovenia, in June 1991, resulted in 5 armed conflicts. 3 of them were international and 2 of them were internal armed conflicts. Slovenia was the smallest war, as we call it, in the region. It had only a couple of hundred of thousands of killed, and it lasted just a few days in 1991. The war in Croatia started in summer 1991 and ended in summer 1995 with Serbs and Croats fighting in that war. Serbs from Croatia with support from Serbia, from the state of Serbia. Bosnia and Herzegovina war was most complicated, with 3 warring sides: Bosniak Muslims, Croats, Bosnian Croats, and Bosnian Serbs. Both Bosnian Croats and Bosnian Serbs were supported by the Croatia and Serbia with weapons, finance and money, and everything that was necessary in order to ethnically clean the territories which they were living from the other 2 nations. And finally Kosovo in 1998, 1999, that was on the territory of Serbia at the time, and the war ended with the 3 months bombing from NATO, which finally decided to militarily intervene against Serbia in the end of 1990s in former Yugoslavia. And finally, the small war in Macedonia, just 1 year in 2001, with, again, as in Slovenia, a few hundred casualties. Especially wars in Croatia, Bosnia and Herzegovina, and Kosovo were characterized with systematic atrocities committed against especially civilian population, with purpose of ethnic cleansing of vast parts of territories. One of the reasons of this bloodshed in Yugoslavia was primarily the aggressive nationalism of peoples living on the territory of the former Yugoslavia, which became a predominant ideology after the crash of the Yugoslav idea of brotherhood and unity. Among them, a particularly dangerous was Serbian nationalism, foremost due to the fact that Serbs were the largest nation living in former Yugoslavia, but also the fusion of territories where ethnic Serbs lived in Croatia and Bosnia and Herzegovina, and the control over Yugoslav People's Army that was, in which Serbs again dominated and controlled it in the beginning of 1990s. With support from Serbia leadership, led by President of Serbia, famous ICTY, or the International Criminal Tribunal for former Yugoslavia, indictee Slobodan Milošević, Serbs in Croatia and Bosnia and Herzegovina established their territories within these newly established states with the purpose of secession and unification of these territories with Serbia. Territory under Croatian Serbs control was destroyed in 2 military actions of Croatian army in 1995, while Bosnian Serbs had to accept the peace negotiations in Dayton after NATO military intervention in summer 1995. After wars in Croatia and Bosnia and Herzegovina ended, Serbia turned to its southern province of Kosovo, where almost a decade of peaceful and non-violent resistance of Kosovo Albanian population against Milošević regime, Kosovo Liberation Army was established in order to separate Kosovo from Serbia through armed resistance and attacking Serbian police and military forces, and also civilians. Insurgencies between KLA and Serbian police turned into a full-blown armed conflict in 1998, and finally NATO took part in spring 1999, and that finally made Slobodan Milošević to withdraw. After he lost presidential elections in 2000, Serbia finally entered democratic transition. In March 2001, Milošević was arrested under charges for corruption in Serbia, and in June 2001 he was transferred to the International Criminal Tribunal for the former Yugoslavia as the first head of state in history to face charges for war crimes, crimes against humanity, and genocide committed in Croatia, Bosnia, and Kosovo. He unfortunately died in the detention unit of the ICTY, not living long enough for the judgment. In wars that we experienced in the region, more than 130,000 people were killed. We have approximately 4.5 million refugees or internally displaced persons, or people who left the region permanently. We ended the wars with 40,000 missing, and we are still looking for approximately 13,000 missing persons in the region. One of the characteristics of the wars waged on the territory of the former Yugoslavia were atrocities that were committed. Massacres of civilians and forced disappearances, concentration camps, systematic rape of women with the purpose of enforced pregnancies, and other forms of sexual violence against women and men. Especially grave was the crime committed by Bosnian Serbs in Srebrenica in summer 1995, where they killed in just a few days approximately 8,000 Bosnian Muslim men and boys. And this event was later qualified by the International Criminal Tribunal for former Yugoslavia as genocide, and this legal qualification was confirmed by the International Court of Justice in 2007. So after a decade spent participating in 4 conflicts in former Yugoslavia and under authoritarian rule of Slobodan Milošević, Serbia entered a period of transition to democracy and peace. It is still facing many challenges: building of democratic institutions after more than 50 years of communist totalitarianism and authoritarian rule, economic transition from socialist to free market economy, and above all, the most delicate and most sensitive question of establishing a responsible attitude about the legacy of war crimes committed by members of Serbian forces in wars as the most important precondition for reconciliation with its neighbors. Although Serbia has achieved some successes in area of democratic and economic transition, I will argue that implementation of comprehensive strategies to face difficult legacy of war crimes and process of reconciliation does not represent a priority for political leadership in Serbia. On the contrary, political leaders almost since the very beginning of democratic transition very successfully and very thoroughly denied any responsibility for the crimes committed by Serbian forces, supporting the feeling of self-victimization for the majority of population, insisting only on crimes committed against Serbs, or tried to justify crimes that Serbian forces committed by equalizing responsibility to all sides in the conflict. Now, how we are doing that? And we are actually a very successful case of how not to apply transitional justice. I will show you that first through the justice and accountability measures of transitional justice. So in 1993, the United Nations Security Council, acting upon the Chapter 7 of the UN Charter, established the ad hoc International Criminal Tribunal for former Yugoslavia in The Hague. At the same time, countries established on the territory of former Yugoslavia and warring sides in two conflicts at the time were not at all impressed with the fact that international tribunal is established somewhere in Netherlands to prosecute responsible for war crimes and other violations of human rights. Actually, I mean, the result is that they really didn't care at all, because you can see that with the fact that although the tribunal was established in 1993, the biggest crime, the genocide in Srebrenica, happened 2 years ago, 2 years after that. And Milosevic forces, together with the Kosovo Liberation Army, targeted civilians recently in Kosovo in 1998 and 1999. So after a very slow start, ICTY became a key for the countries, a key cause or a key obstacle for the countries established on the territory of former Yugoslavia if they wanted to enter European Union and if they wanted to enter the European Union integration process. So basically, ICTY was used as a system of pressure. If you wanted to start negotiations with the European Union, you had to arrest and transfer responsible for war crimes. That was the condition of the international community. And it's very interesting that usually when they talk about carrot and the stick usually works better in the region of former Yugoslavia. So after a very slow beginning of the ICTY, after democratic transition of Serbia and Croatia as the two key countries in the former Yugoslavia, both countries entered the cooperation with the ICTY, but I will focus on Serbia. Serbia was not very happy to cooperate with the ICTY, primarily because ICTY wanted almost all top political and military leaders of Serbia, which basically meant that we had to send a couple of presidents, as a first head of state, Slobodan Milosevic, to face these kind of charges. However, the new government decided to cooperate, and primarily because facing the devastated economy and majority of population exhausted from long period of crisis, Serbian government used ICTY indictees as a ticket to get more financial support from the West. And unfortunately, now where the government made a very serious mistake, it sent that message to the rest of the society and to the rest of the citizens of Serbia. Citizens of Serbia were still holding very nationalistic sentiments. However, the message that was sent to them was relatively okay for them. Former leaders need to be transferred to The Hague primarily because of financial support or the pressure from international community in order for country to enter the European integration process, and not because it was an obligation of Serbia under the international law or the fact that these persons were under suspicion that they instigated, ordered, and participated in war crimes. Serbia arrested several dozens of its former presidents, ministers, chiefs of staff of army, police and army generals, heads of state security service, almost whole political leadership, political and military leadership during the 1990s. While it can be argued that Serbia made significant efforts in this area of transitional justice, and I would say the most than any other country in the region of former Yugoslavia, it is actually, I would say, of great importance for you to understand how bad we apply transitional justice principles is to look at how Serbia is actually responding to the legal conclusions of the tribunal in The Hague. I will show you that through the example of the Declaration on Condemnation of the Crime of Genocide that was adopted in the Serbian National Assembly in 2010. In 2009, following the judgment before the International Court of Justice, which confirmed the legal qualification of Srebrenica crime, that Srebrenica events were genocide, and not only that, that Serbia was partially responsible for violation of the Convention on preventing and punishment of the crime of genocide, becoming the first country in the history of civilization that was declared responsible for violation of this convention. European Parliament adopted the resolution on condemning the genocide in Srebrenica, calling upon all the countries on the territory of Europe, but particularly those in former Yugoslavia, to adopt similar declarations and establish the Day of Remembrance on victims of Srebrenica genocide on 11th of July. Almost a year after, Serbian political leaders achieved a compromise on the text of the declaration, and it entered the parliamentary procedure. Now, this was, I would say, one of the most significant steps in the area of transitional justice. This was taken by Serbia. However, declaration was adopted with a tiny majority, and the problem was that it did not mention the word genocide at all in the text of the declaration. While the international community praised Serbia for this significant step, victims of Srebrenica genocide were not only disappointed, but in a very big, they actually felt quite offended with this effort of Serbia to condemn the crime that happened in Srebrenica. When it comes to domestic prosecution, that is also a place where Serbia had achieved some of the success. In 2004, we have established special war crimes chamber to prosecute responsible for war crimes that were committed in former Yugoslavia. Until now, since 2004, so 9 years, this special war crimes chamber prosecuted or processed 150 people, which is quite impressive if you look at the ICTY that prosecuted 160 people in 20 years. However, among 150 people, only 3 of them belong to army or police. So only 3 of them are actually mid-level or high-level ranked officers of the army and police. And all 147 are actually foot soldiers, members of paramilitary group. So what we have and what we can actually learn from this example is that state institution of Serbia, such as a special war crimes office of the war crimes prosecutor, is actually making significant efforts to present war crimes and the policy of ethnic cleansing as isolated acts of individuals who acted out of control or out of command of any kind of state structure that actually participated in the war. I have 5 more minutes, so I have to really rush. So another thing that really is problematic in the case of transitional justice applied in Serbia is the question of reparations. Now, while Serbia does not have any kind of reparational program, rights of civilian victims and rights of military victims, so military and civilian invalids, are actually defined through true laws that are applied in Serbia since 1997. However, the problem in this case, in the case of reparation, is that the law on civilian victims' rights and benefits is actually quite discriminatory. According to the law that is in force in Serbia, civilian victims are those who suffered body injury until above 50%, and whose suffering was also caused by enemy forces, which basically means that citizens of Serbia who were targeted during Slobodan Milošević regime, who are of different ethnic origin and whose suffering was the result of Serbian police and army, are not qualified to have the status, and they are not recognized as victims in the case of Serbia. So this is another problem and another very wrongly applied principle of transitional justice in Serbia. Another thing that I would like you to present is the case of the truth. Although Serbia did not have any kind of experiments, or the experiment that it had was particularly unsuccessful, the Truth and Reconciliation Commission that was established in 2001, which simply did not publish a single piece of paper or conduct a single day of hearings of victims. I would say that the biggest problem with the truth as a mechanism of transitional justice is more visible in the case of history textbooks that are in use in Serbia. First of all history textbooks currently in use address the history of Yugoslavia, its breakup, and the conflicts, including the circumstances surrounding the emergence of the post-Yugoslav states. When it comes to content of the textbooks that are in use, which deal with interpretation of events from the wars, a significant misinterpretation of the historical fact is visible, and efforts to present Serbs as victims is significant. The part dealing with the war in Croatia contains no mentioning of the role of and responsibility of the former Yugoslav army under Serbian control, which committed massive crimes in 1991. It is, however, noted that the war ended with Croatian military operation against Serbian population, which led to 99% of all ethnic Serbs residing on the territory of Croatia to being driven out and 80% of their houses being burned down. There is not a single reference to the suffering of ethnic Croats during the conflict. When it comes to Bosnia and Herzegovina, Serbian textbooks do mention the massacre in Srebrenica, describing it as a war crime and a crime against humanity, again no word genocide, perpetrated against Bosnian soldiers and civilians by Bosnian Serb armed forces and paramilitaries. The book refers to the total number of victims as disputable, citing those who set the number at around 8,000 and those who claim that figure is exaggerated. Armed conflict in Kosovo is not described as such, but as a clash between Albanian terrorists and the forces of law and order that came from the Serbian side during NATO's aggression on Serbia, and there is no mentioning of Albanian civilian casualties. And finally, although the textbook does name some ethnic Serbs indicted by the ICTY, it does not say what they were accused of. The parts dealing with ethnic Serb victims name those responsible, while victims of other ethnicities, with the exception of those who died in Srebrenica, are spoken of in abstract terms referred to only within the context of all victims of the war. So I would like to conclude with this very problematic area of transitional justice is that I think that this kind of policy in the area of education presents one of the biggest obstacles to reconciliation between Serbia and its neighbors. Misinterpretation of historical facts, portrayal of our side as victims and others as perpetrators, without presenting honest interpretation of the past, creates a fertile ground for new conflicts by turning young generation into prisoners of denial. Thank you.
Okay. Thank you for all to all the panelists for interesting presentations. We now have, we're 5 minutes over time. I'm going to suggest that we allow for 5 minutes for a full 15-minute question-answer period, which means taking off 5 minutes of lunchtime. Is that okay with the organizers? Yeah? Okay. So how do we do this? Do we need mics or not? Okay, so please go to each of the mics, line up at the mic. We're going to take 4 questions at once and then have the panelists answer.
May I start, please?
Please, go ahead.
If we can know or learn, if in the history, modern history at least, there were any cases of turning back refugees to their homelands, that we can say that it was successful and that we maybe can learn from it?
Thank you. Please, over here. Can you, no, is it on?
Can I? Okay, I'm ready. Do I have to say who I am?
If you want, but
okay.
Be brief and concise.
Very brief. Okay.
Yes.
My name is Levana Zamir. I am president of the Jews from Egypt in International and in Israel. I came here to hold your hands to Amutat Zochrot. Please continue, first of all, continue in your fight to get back the Palestinian properties, Arab properties, because I am a refugee, a Jewish refugee from Egypt, and we are a million like me who lost everything, identity from Egyptian authorities, properties, everything.
Okay, do you
and we
have a question?
With 0. My question is to you, Leila Hilal. You talked so sincerely. So do you think that the New America Foundation could also take, you are for the Middle East refugees, could you also talk for us, the million refugees from Arab countries, so we will be together to fight Israel, who didn't want to recognize the lost properties of the Arab Palestinians, and they don't recognize also the million refugees from Arab countries. We are together in this fight. Please.
Thank you.
Together we can do it, because Israel wants to lekazez. They don't want not to return and not to ask back for our properties. Please do it with us. Thank you.
Thank you. Over here. Can you just say it loudly so that we can give you a chance to speak?
Basically, every representative of the Zionist left uses terminology as like human rights and peace. You know, the most just and peaceful solution.
Use the mic.
Here. Okay, please, over here.
Hi, my name is Qusay Abu Akr. I'm from the Haish refugee camp, participants in Campus King Camps project. My wondering here, in this talk and these presentations that are made, are we looking for a solution that is suitable to Israel, not to the Palestinian refugees? And how is that called justice? Thank you.
Okay.
I wanted to ask Ms. Toma. You've spoken. What you said was very interesting to me, but you mainly focused at the elements of criminal justice, punishments, and when we talk about correctional justice, we also talk about. You talked about displaced people. So I was wondering whether the arrangement, if you have any comments also to the questions of land, of refugees, of something that we can, compare exactly to our case. Thank you.
Thank you. Okay. So who wants to answer the question of successful cases of refugee return? Munir?
Yes.
This, yes.
The simple answer is yes about the return of refugees. I have examined a number of cases during my research, including Liberia, East Timor, Colombia, Bosnia, South Africa, and a few other cases. In all of them, there was a return of refugees. It was an integral part of the process. It was an important part of the process. And the whole transitional justice process was actually about the return. The question was not in any of them whether the return is going to be implemented or not, but how it is going to be implemented, and how we're going to give the victims the feeling that their rights are going to be redressed.
And which one was successful?
I would say the levels of success were varied from one to another.
What is a measure of success?
The measure of success?
One measure.
Well, the actual return. But then the question is not, it's in cases when return was actually established, the questions would be how are we going to integrate them? And then the questions are they well integrated into their old new society or not? And also a big problem that comes up is how restitution, actually. Restitution is always a big problem. How we are going to, and another problem is usually finance. How are we going to finance their return? How are we going to build homes? And all of these are normally the questions that come up, but not return.
Okay. I'm going to ask Marijana to answer that very briefly, because there was a lot of return in the Balkans.
Yes, well, when it comes to the return, especially in the case of Bosnia and Herzegovina, that case was, and it is right now in the process of resolving. However, there are issues in relation to property, especially in the case of between Croatia and Serbia, and there is also a problem in return of Serbian refugees from Croatia who decided, primarily because of some of the first measures of the Croatian government after 1995, which basically prevent them from returning. And also the problem in relation to the what Serbia calls IDPs, but there are refugees, so Serbs from Kosovo. They are actually facing a serious discrimination in Serbia because they are not acknowledged as refugees, because Serbia does not acknowledge Kosovo as the foreign country, as independent country, so it gives them the status of IDPs. Its own ethnic group. And the problem is, especially in the case of return to Kosovo, in the case of non-Albanians returning to Kosovo, are not systematic, but incidents, for example, attacks on returnees, murders, killings, and so on. So it presents a very big problem in that case.
Okay, so more problems and challenges. Yoav, can you just very brief on this question?
Yes, רק במשפט אחד.
Very, very quickly, the questions in regards to comparisons, I think these comparisons are done oftentimes in order to create a situation in which the issue of refugees is off the agenda, to take it off. I think obviously the issue exists, and forgetting history, I mean, I don't think that is, maybe the question should be, that in circumstances where people are trying to forget history, what do we do then? And I think that, from what I know, actually this doesn't happen better of people trying to forget history than people who try to deal with history and tackle it head on.
I'm actually going to ask that each of the panelists comment next on the question of, are we speaking of justice for Israel or justice for Palestinians? Yes, please.
Yes, I'll answer this question literally. Of course, we are not looking, at least I, who was speaking and am committed to a specific kind of formula. Of course, we're not looking for something that will please the Israelis only. That's the literal answer to your question. It was a rhetoric question, I understand. Doing that would completely defeat the purpose of getting reconciliation. It would get other things. So that's not not what I'm on about. I may have not done a very good job, and others also, in finding something that would sound to everyone as a successful address of both sides, but certainly not trying to please one side on its own. I would also reiterate what I said in my paper, and that is to warn against seeking ultimate justice as seen by one of the sides as a way forward. I think that would only delay and obfuscate ways to proceed. So, a very direct answer to your question.
הקורבנות או...
The conflict is asymmetrical. I mean, the victims are very clear. The victims are Palestinians. So obviously justice must address what happened to them, to the victims. But the question is, are you saying, okay, any justice is absolute justice, the way that you said earlier, sir? Or are you also addressing the strong side, so to speak, the Jewish Israeli side, and saying, okay, the Jews are, we won't give justice to the Palestinians because this will be an injustice to the Jews. No, you try to find a way in which the Jewish Israeli side can also define itself the way it wants to define itself.
I will answer this in Arabic. بدي أجاوب الأخ
لما أنا مقبلت الزي
الأخ من الدهيشة إنه فعليا إذا العدالة الانتقالية تم تطبيقها حسب المفهوم الحقيقي.
I would like to answer this question. Usually this kind of mentality is based not only on truth, but also on all of the elements that include the return of the refugees, the distributions, and the change of the legislation in Israel as it stands at the moment, which is discriminating against the Palestinians. If such settlements are implemented in such a way, then obviously at the end of it, the resolution will not be accepted by Israel and will not be preferred by the Israeli side, because the entire problem of the refugees has to be has to do with the fact that Israelis define themselves as a Jewish state, and they emphasize the fact that they are Jewish state, and so international law does not acknowledge a principle of an ethnicity of a state, but rather the return of rights. So if we would like to implement this transitional justice tenet in an equitable way, it should be to the benefit of the victims and the refugees that suffer daily. And this is certainly not something that will be very happy for the Israeli side, obviously. But I do hope that it does please the country that we would like to be in one day, which is a country of equality that we will manifest by creating transitional justice.
Yes. My simple answer about Jewish refugees in the Arab world is yes. I will be very happy to fight with you and with everybody else who demands their rights in any Arab country, including Egypt, Lebanon, Syria, Morocco, etc. Of course, just in the same way that the Palestinians are entitled to their rights in Israel or in the occupied territory, Jews who are displaced and who have any property in the Arab world are not only entitled to their property, but are also entitled to their citizenships and to their full rights. So yes, if you need, if you work for the same rights and you see that they are equal in Israel and Egypt, yes, I'm very happy to be on your side.
I'm sorry, but we don't have any more time left. I know there was one more question regarding Marijana's presentation. The Serbian example focused very much on prosecutions. The question is that relevant for Israel-Palestine? And I think that's an important one, and I would encourage people to approach you for discussion.
The gentleman
after.
did not get his chance to...
No, I'm sorry. We have a lot to cover. We have many panels and many speakers today. Thank you.
I said that basically